Prior user rights. These provide protection to third parties who in good faith start to use an invention prior to a patent application being filed by someone else. 18-month publication. Virtually all countries, other than the US, require the publication of all patent filings at 18 months from filing, unless there are security or morality issues involved. Our industry has made considerable progress, but has not solved all these issues. The industry proposals will be published shortly, so that they can be discussed at a symposium organised by the European Patent Office on June 20th in Munich. KIPO, the Korean IP Association, KIMPA, and KPAA will all be participating at this EPO symposium. This is not the first attempt to reach consensus on these difficult issues. However, if agreement can be reached, it would demonstrate the desire to adopt a more global approach to patent laws. Inventors, particularly SMEs, have difficulties in understanding why, for example, they can get a patent on their invention in the USA, but not in Europe and Japan. Substantive patent law harmonization would be a big first step in overcoming this. To have a good IP system, a country needs to provide effective enforcement of IP. This is true now and will continue to be true in the future. A country's courts therefore need to be accessible to those who have or want to use them, not just those who have money. The courts need to give their decisions in a reasonable timescale. They should provide value for money. To spend $1 million to get back only $500,000 in damages and not recover all your legal costs is not good value. Courts should also make quality decisions. Consistency is important here, as industry requires certainty to enable it to make its planning and investment decisions. I believe the UK has a good court system for IP cases, and a Taylor-Wessing survey was seen to support me in this. So how has it achieved this? Well, it has specialist IP judges and specialist IP courts at first instance, the Intellectual Property Enterprise Court, IPEC, and the Patents Court. It also has 2 specialist IP judges in the Court of Appeal, and the President of the Supreme Court has experience of and interest in IP matters. I even sat on the same panel as him once at an IP conference. The UK provides a flexible system with cases of lower value going to the Intellectual Property Enterprise Court and its Small Claims Court, which only deals with trademark, copyright and designs cases. Those of higher value go to the Patents Court. The predecessor of the IPEC, the Patents County Court, was set up to allow access to justice to a wider part of society, and when it became the IPEC, it had a set of procedures aimed to decrease the cost and increase the speed of procedures. It has been so successful that the Patents Court has adopted some of these procedures. Both the IPEC and the Patents Court provide for limited discovery at the discretion of the judges. A request for discovery will normally be allowed, but a case has to be made out. Similarly, cross-examination is at the discretion of the judge and is more limited in the IPEC. Decisions in both courts will normally be given within 1 year and can be faster if circumstances and the parties can justify this. Damages and costs are capped at the IPEC, so it's a maximum of £500,000 in damages and a maximum of £50,000 worth of costs are awarded, but not in the Patents Court. The courts are also using the latest IT technology and are prepared to take testimony by video link if necessary. Most UK patent attorneys are qualified to represent clients before the IPEC, and those with high litigation qualifications are also entitled to represent clients before the Patents County Court. UK patent attorneys with litigation qualifications, which is most of them, are qualified to represent clients before the new Unified Patent Court, which is discussed on the next slide. After the referendum in the UK in June 2016 concerning leaving the EU, there was some concern as to whether or not the UK would participate in the proposed new European Unified Patent Court. However, in November, the government announced that it will continue to be part of the preparations for the establishment of the UPC. A timetable was published by the preparatory committee indicating that the court would open for business in December 2017. However, 13 countries, including the UK, France and Germany, had to ratify the international treaty before it could come into force. Germany is not expected to ratify until September, and the UK's ratification plans have been delayed by the government calling an election, so it seems very unlikely that the December date will be met. The UPC is a mixture of central and local divisions. There are 3 central divisions, one in Paris, which also has the registry, one in Munich, and a life science division in London. The London court is ready to go. There will also be local and regional divisions in a number of other countries. France, Germany and the UK have local divisions as well as parts of the central division. The Court of Appeal will be in Luxembourg. European patent attorneys qualified to appear before their national courts will have the right to represent clients before the UPC. Therefore, unless the rules are changed, UK patent attorneys should be able to represent clients before the UPC whether or not the UK continues to participate in it. Patent attorneys need to adapt to meet the changing environment they find themselves in. The patent attorney of the future needs to consider how he can best add value to his client's activities. There are several ways he can do this, and some of these are portrayed on the slide, but the list is not inclusive. Helping the client with portfolio optimization is a straightforward extension of current activities, and many patent attorneys may already do this. The patent attorney should understand the client's business strategy and design and shape the patent portfolio to support this. He should also be able to consider associated rights, for example, design protection, or, in the case of pharmaceuticals, data protection. Patent attorneys should also be able to represent their clients in court. This is especially important for SMEs, small, medium-sized enterprises, who cannot necessarily afford expensive legal teams. The patent attorney understands the technology and is in an excellent position to advise and represent his client. Advice on IP monetization is also important for smaller businesses. Patent attorneys can help their clients generate revenue by monetizing their intellectual property. In the area of technology transfer, patent attorneys can help their clients reach appropriate agreements in relation to both in-licensing and out-licensing. Again, their understanding of their client's technology and business plans help them in this. In relation to tax, many governments are now offering tax incentives to support R&D initiatives and patent filings associated with these. For example, the patent box in the UK. Patent attorneys can help their clients by identifying suitable opportunities for these tax incentives and the requirements to qualify for them. Intellectual property is an asset that can be used to secure investment. This is particularly the case for start-up companies, where often their main and sometimes their only asset is IP. Again, patent attorneys can assist in the generation of the IP in the first place, and even in the process of valuation of the IP. I could not miss this opportunity to say a little about the future IP environment in the UK after it leaves the EU. The UK will continue to be part of the European Patent Convention after Brexit, and UK patent attorneys will continue to be able to represent clients before the European Patent Office. Because neither the European Patent Convention nor the European Patent Office are EU institutions. It is therefore very much business as usual. Brexit offers the UK opportunities in the IP area as well as challenges. SEPA is considering these opportunities carefully, and some examples are shown on this slide. Supplementary protection certificates, SPCs, are granted on patented pharmaceutical and crop protection products that suffer regulatory delays in getting product approval. When the UK is not bound by EU laws, it could expand the protection to other patented products that suffer regulatory delays. For example, medical devices and even products in the aerospace industry. The effective term of the patent plus SPC term for pharmaceuticals has decreased since SPCs were introduced in 1993. The UK could consider restoring the effective term to what was intended when the right was introduced. The tax relief offered by the UK in the IP area was criticised by other EU countries and had to be restricted. There will be more flexibility when the UK leaves the EU, and it could be made more generous. There are pieces of EU legislation that are believed to inhibit R&D in some areas. The Biotech Directive and the Nagoya Protocol are two examples of these. The UK could decide not to continue to have these as UK law in their current form once it has left the EU. In conclusion, governments, IP courts, and patent attorneys have been increasingly working together over the last decade to make the IP system more efficient and user-friendly. The major patent offices are working together and with their users to make the patent granting process for patents more predictable and for grant to occur more rapidly. Courts are becoming more responsive to their users, and new IP courts are being established. It is important that patent attorneys should be allowed to represent their clients before IP courts. Patent attorneys should also continue to look for further ways to add value to their clients' activities, not just focusing on patent drafting and prosecution, but handling other matters as well. All these activities must continue to ensure the system continues to be fit for purpose and for it to be able to cope with major technological innovations going forward. The patent system has been the driver for industrial growth for at least the last 2 centuries and has shown how it can adapt for the better. Stakeholders should continue to collaborate to make sure this continues. Well, thank you very much for your attention, and thank you also for the translators, who I hope have translated it all correctly. Thank you very much.
Thank you, Mr. Rollins. 토니 로렌스 회장님 감사합니다.